And we are live. So, welcome everyone. Good morning and good afternoon to you all from East to West. It is a pleasure to be here and to welcome you for the Privacy Rules Global Data Privacy Day session. And I'm pleased to kick our series of sessions of today with our APAC session. We will be speaking about privacy and AI developments in the APAC jurisdictions with the focus from India and Japan together with our experts. But we will not miss the opportunity about speaking of the South Korean AI Basic Act, which is one of the relevant topics of the moment and of today. For the ones that don't know Privacy Rules yet, let me just give you a little overview. Privacy Rules is a global alliance of experts specialized in privacy and data protection, but also flanked by experts from cybersecurity area as well as crisis communication area. And we now cover almost 60 countries from all over the world to provide better services and combined services to all the clients of the members of our alliance, as well as everyone that contact us to be supported worldwide. Without further delay, I would like to kick off this session, but I have to remind you all that you can interact with us. So please feel free to use the open chat to provide your questions and comments to us all in order to have a very interactive and open session. And without further delay, I would like to introduce you to our two experts of the day. The first is Minako Ikeda from Iwata Godo, a Japanese law firm, with which we will delve indeed into the framework in Japan and some updates from other countries, as well as Stephen Matthias from Kochar & Co. from India. Two great experts specialized in privacy and data protection, with which we will delve a bit into APAC jurisdiction and the latest trends and news on technologies in this area. So first of all, welcome Minako, and welcome also Stephen. Nice to have you here.
Thank you for having us today.
Okay,
Thanks.
so it's a pleasure. It's a pleasure. So let's immediately start because the time is very short in this session. Indeed, we have just about 30 to 40 minutes to discuss together. As said, we want to have an overview on what's happening in key jurisdiction as yours. So, let's start with the general overview on what's happening in your respective jurisdiction. I think one of the most relevant news of the moment is related to the new rules coming from India. So I would like to start, Stephen, with you. Can you provide us with a little update on what's happening there and what's the scene and the situation in India right now?
Sure. So, as you may know, in August 2023, the Indian government enacted the data protection law in India, and it was passed by Parliament, approved by the President. But it has not come into force yet. The main reason being that they needed to prepare certain rules that would implement the law. And it's taken a while for the government to prepare those rules. And recently, they released a copy of the draft rules. So the process now is they were looking for public feedback till February 18th, and after that they will review the feedback, and then they'll finalize the rules, and then very likely they will, bring the act into force. So I expect the law will probably come into force by the middle of this year. I'm not sure what will be the gestation period, but I don't think it will be too long because India does not have a record of a very long period for implementation in the past. And of course, the law has been around for more than a year already, so everyone knows what's written in the law. Some things that are relevant to the new rules. One of the key issues relates to the fact that there's no principles based ground for processing of personal data. It's almost entirely focused on consent, and the language used to define consent is almost the same as under GDPR, that it must be freely given, specific, informed, unambiguous indication of consent, clear affirmative action, and also one additional term, which is it should be unconditional. So the question really here was, is India going the GDPR way in terms of how consent is obtained or not? It's important here because my understanding is from most privacy practitioners in the EU, very few cases actually use consent. Most of the time, people use legitimate interest. So they don't go down that consent path because it's considered to be too difficult. So the rules here, by and large, confirm that we would go the GDPR route, which is providing an itemized description of personal data along with specified purposes, itemized description of the goods and services to be provided as a result of such processing. So this is a significant departure from the standards that are normally used when preparing privacy notices and privacy policies. And it does mean that very likely a GDPR compliant privacy policy that's based on legitimate interest would not work for India. There was some concern over the fact that you need to provide the privacy notice at the choice of the data subject in any of 22 languages. So it was hoped there would be some form of liberalization here, but this is not covered in the rules. So it seems like if someone wants the notice in one of those 22 languages, you'll need to give it to them in that. The statute talks about using reasonable security safeguards, and the rules have gone further to describe what that is. Encryption, obfuscation, or masking of personal information, use of virtual tokens, restrictions on access, visibility on access through maintaining logs, requirement of maintaining logs for a period of 1 year, and so on. But what's not clear in the rules is, do you use one of those or some of those? It seems like you have to use all of them, and so I think that's a very hard thing. And you have different businesses who use personal data in different ways. For them to use all of this would be extremely difficult. So again, it's somewhat of a disappointing development. Then we come to more disappointments in terms of data breach notifications. The statute was quite strict here as well, in the sense it requires you to notify the data subject and the data protection authority in every case of a data breach. So now they have introduced their actual standards. So for both, you have to notify without delay. But with regard to the DPA, which is called the Data Protection Board of India, there's actually a two-stage reporting, which is that initially you report without delay, and then you have another 72 hours to provide further reporting with more information. Given the fact that we also have a cybersecurity reporting to the CERT, India is looking at the possibility that if you have a data breach, you may have to do four reportings. It seems incredible, but that is the way the law is looking at the moment. On data localization, the government, through its 5 drafts, was kind of focused on data localization. But when the final statute came out, all they said is that they will create a blacklist of countries, and you can't send personal information to those countries. Now the government seems to have gone back there, and it seems to have given itself the right to impose restrictions on the transfer of personal data to any country. So again, that's not such great news in terms of data localization. There is some standards with regard to verifiable consent to be taken by a parent for applicability to children, and there are no standards added for government's power to call for information under the Act. So this again is troubling, especially for the EU, and in light of the Schrems II judgment, and that the fact that surveillance of personal data needs to be limited and so on. So that's roughly what's covered in the rules, and overall, it's the rules rather than kind of clarifying the law and making it easier to comply seems to be have made it much more difficult to comply with. I would add though that these are draft rules and there is feedback from industry, so you never know, the government may go back on this in the final draft.
Perfect, Stephen. Thanks a lot for this brief overview. There is a lot of changes, but also a lot that we might expect to be changed and revised according to your comments that were very insightful. So thanks a lot for that. And I will move to Japan now. So Minako, what's the stage in Japan for what concerns, at least for now, data privacy laws, and so data protection only?
So in Japan, the Japanese DPA is now discussing to amend the data protection law, and the draft is expected to come out. Still a draft, it's not concrete yet, but I would like to highlight the main issues currently under discussion and consideration by the DPA. The first one is introducing regulations for children's personal information. Currently, there are no regulations in the law concerning children's personal information. It's only providing the guidelines that parents must give consent to processing of their children's personal information on their behalf for children under the age of around 12 and 15. So currently, the DP is considering several ways to increase the level of protection of children's personal information, such as making it legal obligation to obtain parents' consent, and also requiring businesses to implement security measures with a higher level of protection for children's information compared to other adults' information. The second point would be establishing effective rules for biometric data. Biometric data is not categorized as sensitive personal data under the Japanese law. The DP is considering introducing new rules, such as requiring businesses which process biometric data to specify what kind of service or project such data may be used for when specifying and notifying the purpose of use to data subjects. Also, reportable data breach incidents may be changed, may be redefined based on a risk-based approach. For example, currently, illegal transfer of personal data to a third party is not categorized as reportable data breach incident, but the DPA is considering amending the definition of reportable incidents to include such illegal transfer of personal data. And lastly, the DPA is thinking of strengthening the enforcement of data protection law in Japan. Currently, enforcement primarily relies on administrative guidance and recommendations by the DPA. and formal orders by the DPA are extremely rare. And criminal penalties are only applied when such rare orders are violated. So, in the next amendment, the DPA is considering introducing administrative fines similar to other jurisdictions. Although it is likely that fines will only be imposed in cases of serious infringement of data subjects' interest, such as unauthorized acquisition of personal data. So it's nowhere near close to the situation in EU or many other jurisdictions, but the Japanese DPA is keen on increasing the level of enforcement of the law.
Thank you. A lot of notes that I'm taking because this is very interesting. I think the key points to underline is that we're both speaking about draft laws, so still something that might be changed in the near future. Which brings me to my next two questions in one. The first one is about how do you expect your authorities to move on with the next steps? Do you think that some changes in particular are going to come, some parts based on the feedback they are receiving from companies and organizations might change in the near future? And on the other side, we have been focusing just on data protection laws, but are there other laws that companies should be aware of because they are combined with data protection ones at the same time? And Minako, this time I would start with you and then move to Stephen.
So the privacy, the data protection law (APPI) will be amended. It was expected. The draft law was expected to be submitted to the Diet spring of this year. It may be delayed a bit, but it will come out in the near future. So the amendment to the data privacy law will happen in the near future. But on a different but related topic, the government will submit a bill to the ordinary session of the Diet probably next month concerning the research and development of AI and its use in Japan. As many of you know, Japan has been taking a soft law approach in AI governance and has left it up to businesses to take voluntary action, and the government's been encouraging self-regulation through guidelines to promote corporate activities such as research investment, but it is now changing its course to some degree. Yes. So that's a new law that, well, it's still a bill, but I think that will be passed in the session, the Diet.
Thank you very much, Minako. And Stephen, what about India? Is there, what do you foresee as next step? I think one of the key questions we were receiving whenever speaking about India is, given all those points that you've been raising as an issue, do you believe that even if the law pass and becomes effective, there will be a soft approach by the authorities in any case, or not, and on what? And of course, if there are any other laws of specific interest that we should know about.
Sure. I don't expect a soft approach for the reason that now they have had the time of more than 1 year to, consider all the feedback from the statute. The final version of the statute was not released to the public in advance. It was just introduced in Parliament and it was passed in a matter of a few hours. So they had that time after the statute was passed, before they prepared the rules, and the rules are even stricter than the statute. So I don't expect we'll see a more lenient approach from the authorities. Coming to other laws, we obviously have sectoral laws. By and large, they cover a few things. One is security standards, mostly encryption levels. Two is some amount of data localization. So, for example, in areas like telecom, banking, insurance, and so on, there are some data localization requirements. And then we have the cybersecurity law, which is where if you have a cybersecurity incident and it results in a data breach, then you've got to notify the CERT within 6 hours. In practice, I've done maybe about 2 dozen of them in the last couple of years, and not a single one of them were my clients able to notify within 6 hours. But what's troubling there is the CRT does come back with additional information. They want reports to be filed. They have even asked for logs, which are very hard to for an organization to provide. So that's another area of law, and it doesn't look like that area of law is going away because that's not privacy law; it's more cybersecurity law. So that's by and large the landscape of laws applicable to privacy, but not part of the main data privacy law.
Perfect, Stephen. Thanks a lot for this brief intro, and thanks a lot, Minako, as well. Related to that, Minako, I heard you mentioning about AI, which is the other topic we wanted to touch upon together with you today. So can you provide us an overview on the stage of AI in Japan, and then maybe we can move to South Korea a little bit, because there is strong interest on that as well.
As explained, Japan has been encouraging self-regulation through guidelines such as the AI guidelines in business to promote research and investment in the private sector. But considering the trend overseas, such as the EU, the government has decided to change its policy and is aiming to enact a new law concerning AI. And this bill includes provisions to allow the government to investigate businesses that develop large-scale AI models. And the bill also clearly states that the government will investigate malicious cases regardless of the scale of the AI models, and that businesses will be obliged to cooperate with the government's investigation. And the government will be able to provide guidance and advice to businesses based on the results of such investigation, which will also be accessible by the public. And this bill provides that the law is applicable to businesses outside Japan as well, so it does have an international impact. However, the bill does not include provisions for penalties, taking into account voices from major developers and other businesses, which oppose to excessive regulation. So the effectiveness of this new law will be an issue even if it is passed. So Japan is moving towards more regulation in the AI field compared to the approach taken before, but it's nowhere close to the situation in South Korea, which, as Alessandro, you mentioned, just recently passed the AI Framework Act.
Thanks, Minako, and you led to your next question already. So can you also tell us a bit more about South Korea, and also can you tell us if you believe that this might change a bit the approach in the entire region and in the entire area, because it's a relevant news. From the privacy law side, we have seen the UAI Act happening. We know that in Colorado, in the US, there is a new AI law coming and discussed. So happy to know what's happening in the APAC jurisdiction and how this might affect it.
Mm-hmm. So South Korea became the second, I believe, country in the world, following the EU, to enact a comprehensive regulatory law on AI. And the name is, as I just mentioned, is called AI Framework Act. It will take effect January next year, so there is 1 year to prepare. It might be easier to understand this new South Korean law by comparing it with the EU AI Act. So I will like to highlight a few differences between the two acts. First of all, while the EU AI Act focuses on prohibited AI practices and high-risk AI systems, as well as general-purpose AI models, the Korean AI Framework Act primarily regulates high-impact AI systems and generative AI. And these high-impact AI systems are defined as those used in 11 specified areas that may significantly impact or pose risks to human life, physical safety, and fundamental rights. And these 11 areas include energy, health and medical service, medical device, management of nuclear facilities, criminal investigation, and transportation infrastructure. Um, Further, obligations of each type of participants in the AI value chain differ under the EU AI Act, but under the Korean law, the laws provides for comprehensive obligations regardless of the role in the value chain. So that is another difference. Um, One similarity is that the AI Framework Act may apply to businesses not established in Korea, as it applies to acts conducted outside Korea as long as it affects Korean domestic market or users in Korea. Um, we still have to wait for subordinate legislation and guidelines to come out to have a better understanding of what falls under the high impact AI systems and therefore how it may impact international community. But mentioning the influence it may have to on Japan, on how Japan regards AI governance, it may help the government to implement more regulation in the AI field, but I personally think it may not it may not have a big impact. Japan will stick to leaving it to the private sector to self-regulate. Although the bill that I just explained about will most likely be passed in the diet, but as I just explained, there are no provisions on penalties, so it won't have a strong enforcement effect. So yes, that is what I think about impact of the Korean law to Japan.
Thank you very much, Minako. I think it's interesting to see the different approach also in Japan by not issuing for the moment fines and really trusting the companies. I think it's something that we didn't see in the EU, where the approach has been in giving enforcement powerful capacity to make all the companies compliant. Let's see, but it's very interesting to hear about it. Stephen, is there any update on AI from India as well? And what do you think about the South Korean AI Act? Do you believe it might impact your situation, or maybe the EU AI Act was more impactful for you?
Right. So we've had just one regulation that was issued in March of 2024, and basically it covered a bunch of things. So, intermediaries should ensure that unlawful content is not uploaded using AI. There should be no bias or discrimination that would threaten the integrity of the electoral process. It prescribed labeling mechanisms and consent pop-up mechanisms with regard to the fact that AI-related content may be unreliable. Users should be informed that uploading of unlawful content would be illegal. And there was a requirement that for AI that is under testing or is unreliable, permission of the Indian government would be required. But then they pulled that back because they realized it was just impossible. This was mostly a reaction to some fear that you could have a lot of deep fakes just before the elections, which luckily didn't occur, and the elections went off smoothly without much use of deep fakes. And so that's kind of the past. In January this year, a subcommittee that was appointed issued a report, and they came up with a bunch of recommendations. A key one is that the government should adopt what they call a whole of government approach to AI governance. I think what that really means is that the approach to AI governance should be done collectively by everyone in the government. And what that's really good because it protects against overzealous bureaucrats in some particular department of the government issuing something on AI, which impacts industry very broadly. So, a coordinated approach would certainly work. They plan to set up a technical secretariat. They do want the secretariat to develop an AI incident database. I'm hoping that does not result in more incident response reporting requirements, and to work with industry to develop voluntary commitments on transparency. That's essentially what's covered in this report, which was issued in early January. By and large, the government is not looking to enact a statute on AI at the moment. I think it's a wait and watch approach, and it's a more of a collaborative effort with industry, and I think that's good because I don't think India is really at a stage where we can do that. So probably minimal impact of the EU and South Korean legislations on India.
Thank you very much, Stephen, also for your overview. And I would like to, we have about 10 minutes before the conclusion. I would like to move on the more practical side of the discussion. And the first question, and this is something we were also receiving, in the comments while organizing the event, is very much related indeed to notification in India, Stephen. The main question is how to deal with those many notifications requirement that are coming also from different authority. Can you use the same approach to each of them? Are the notification requirements similar, or there are also differences that make the framework even more complex? And this is very interesting, and one of the key reasons I believe audience is asking about it is that also in the EU, we are seeing a further level of complexity in notification requirements by separate regulations and sometimes separate institutions. So how are you dealing with it in India? Because you also have very, very, very strict and tight time frames to notify the authorities.
Yeah. So these draft rules have been around for only a few weeks and they are only in draft stage. So while they are troubling, we don't know what the final rules will say. We do know that notification to data subjects and to the DPA is certain because it's there in the statute and it can't be changed unless you amend the statute by Parliament. The cybersecurity notifications, which is 6 hours, as I said, I've not seen a client who's actually notified within 6 hours. And in fact, for many months, the form that you had to use did not even specify when you got to, when to disclose when you had come to know of the data breach, which is now required. I think the troubling part is not so much the initial data breach requirement, but the requirements thereafter when the CRT replies. For instance, in some cases, they've asked for a forensic report. In other cases, they've asked for logs. And especially big, large multinationals and so on who house their data outside India, they're not very keen to provide that. So I think that's a kind of tricky aspect. By and large, I think India has a long history of over-regulation, and it doesn't. It's not just data privacy, but it's pretty much everywhere, in like corporate law, for instance, employment law. So maybe international council who used to dealing with India will not be that surprised that you will have 4 different notifications to issue when you have a data breach, and hopefully it's not an AI incident as well, because then it might even become 5. I think obviously the content you're providing is pretty similar, and it's a question of just putting the right content in the right form. But of course, it is more work, and of course, more work for lawyers like myself.
Of course, thanks a lot, Stephen. That was extremely useful. And let's see. And Minako, what about Japan? To you, I would make a bit broader question, meaning, which are the key challenges that you are facing? What are you and your clients in particular looking at? Is there something you are preparing, also considering this draft law coming?
Um, Not specifically in relation to the draft law, but um, the key issues that many of our clients face is international data transfer and implementing effective data privacy compliance measures among group companies around the world. To have an effective compliance system, of course, the key point is to prepare a system and implement measures that is customized based on how personal data is processed by the client and its group companies globally, and to prepare customized compliance measures, taking into account how the data is transferred and being processed by each group companies. And to do that, it's important to understand the key differences among data privacy laws in various jurisdictions where the group companies are located, as well as the level of enforcement by the authorities. And it's important to understand that before conducting data mapping. And that can take quite a lot of time, which also means increased legal fees for the client. Well, in many cases, we advise clients to prioritize certain jurisdictions over others depending on their budget. And our firm, we can do that. We can provide efficient and cost-effective advice and service in this regard using the Privacy Rules Network, where we have close and good relationship with reliable experts around the world.
Thank you very much, Minako. I think that's why one of the key reasons why we exist. In some cases, it's essential for lawyers to know which is the approach, country by country, in order to identify priorities for your clients. So knowing that an authority it is or might be in the near future, very strict, is good to know, so that you can prioritize that country, as well as knowing the level of complexity of the legal framework of a center country. And I also believe, it's good also to have comparisons between the various frameworks to make sure that, steps you have already taken for one country maybe can be reused for others, because maybe some requirements are very similar. You raised the point of data transfer, which I would like to bring also to Stephen now, because I know that's one of the key topics to handle for all data privacy lawyers working internationally. So Stephen, how does it work for you and for India? Are you facing the same type of hurdles, and then you're supporting your clients in the same way, or your approach is a bit different?
So, except for sectoral regulations where you do see some restrictions on data transfer, that is data localization, the statute itself is fairly liberal. It just says that the government will create a blacklist of countries that to whom personal data cannot be transferred. I think there are basically two categories here. One are countries that don't have sufficiently high standards of data protection, and the other are countries who are perceived to be, unfriendly to India. That's mostly focused on China. The privacy rules do kind of take a step back, in the sense that it does give the power the right to impose conditions on data transfers out of India. And there is a question as to whether that is ultra vires the statute, because the statute does not give any such power to the government to do that. So it remains to be seen, but I expect there will be some restrictions imposed even for uh, data transfers to kind of friendly, well-regulated countries.
Perfect. Thank you very much, Stephen. And I know that in India, one other topic was the one related to privacy notices and privacy policies, which is something very close. What's your approach with that?
We'll have to look at a granular privacy notice where you list in an itemized fashion all of the personal information being collected, and match that with the purposes for each, and then obtain consent for each. I know it's really tough, and there are very few countries in the world where something like that is actually required, and you have no other option, like say let's split interest. But it looks like that's the way India is going.
Perfect. Thanks a lot for this, Stephen. I was also receiving a question that is pretty specific and is related to how would you approach data protection impact assessment in particular. That was for Japan and a bit for South Korea, I believe, in a comparison with the ones in the EU. They were relating this to AI, but we would like to extend when you process and run data protection impact assessment. Do you use models that are similar to the ones in the EU, or you have a completely different approach from them?
So in Japan, impact assessment is not mandatory. And it is up to each businesses to perform the assessment. So there is no official way of that the businesses must follow in order to conduct the impact assessment. And I am not sure what the situation is in South Korea, so I cannot make any comments on that effect. Introducing the requirement on impact assessment was one of the topic discussed at the DPA during the discussions for the current the next amendment to the law, but the DPA is still quite cautious in introducing such obligation, in addition to the appointment of the DPO, which is not a requirement under Japanese law.
And Stephen, what about India?
So, as is usually the case with India, we've kind of gone overboard. We have a concept of a significant data fiduciary, and largely it's a data controller that deals with a very large amount of data, and it's not yet clear who exactly will be covered in that. But the significant data fiduciaries will have to do a data impact assessment every year, as well as an audit every year.
Perfect, Stephen. Thanks a lot. And we are running out of our time. So I would like to ask the two of you for your closing remarks with a look at the future and 2025. So leave it to you to provide any comment that think might be useful and worthwhile, as always, from you for our audience. Minako, you first.
I'd like to thank for your time today. And while the Japanese law in many cases is not as strict as those compared to the laws in the EU or other jurisdictions. As I explained, the DPA is keen on moving towards heavier regulation, both in the data privacy field, and also the government is moving towards to a different approach in the AI field as well. So businesses who have any business issues in Japan, please feel free to get in touch if you have any issues or questions about data privacy or technology in Japan, and I'll be happy to provide advice.
Thank you. Thank you very much, Minako. And Stephen, to you.
So I think now with the statute passed and with the draft rules out, it's worthwhile for businesses to start preparing to comply with the new law. While it may not result in a finalization of a data privacy policy or a notice, or making decisions on how exactly you want to deal with the data, one should definitely discuss, understand, and strategize as what's the best way to comply with the law, but then not proceed yet to implement, because we need to see the final rules and understand what they say, and at that point one would actually proceed to implement.
Perfect. thank you very much. It's time to close our session. Also, because I would like to invite our audience to stay and to follow the coming one in about 10, 12 minutes, where we will be speaking about EU in particular, with an eye on how our companies struggling to use AI tools in the current regulatory environment in the EU. So thanks a lot for this quick overview and focus on the APAC jurisdiction, to you, Stephen, and to Minako. Looking forward to meet you again soon, and to see our audience in the next session that will be driven by our colleagues from the MLEX team, together with another great panel of experts from the EU specifically. So thank you all. Looking forward to the next session, and bye everyone.
Bye.
Good morning, everyone, and welcome to the Privacy Rules MLEX seminar on companies struggling to use AI tools in the current regulatory environment. Happy Data Protection Day. It's Tuesday, and we already have some important announcements in the world of AI that everyone is paying attention to, and that's coming from a big concern in Silicon Valley about a company that most people had never heard of out of China and called DeepSeek. And now the big concern is about what's going to happen with competition from Chinese AI developers. So that's just to put our focus on how important AI is to the world of business, stock market, and of course for us, data protection. So that's what we're here to talk about today. I'd like to introduce the panel. We have an expert panel today. We have Gert Sommers, who's a partner at TimeLex. We have Luca Tosani, who is a former specialist and legal director at the for international affairs at the Norwegian DPA, and he's now a managing associate at Schott. And we also have Lauren Lindhout, who is Director of EU Government Affairs at Microsoft in Brussels. So I'll give a short introduction, very short, and then we will launch into the webinar straight off. So as I was mentioning about AI models, they're in the news every day. They rely on large data sets that often contain sensitive or personal data. Businesses must ensure that they mitigate AI data privacy issues. On the 18th of December, 2024, the European Data Protection Board released an opinion on the processing of processing of personal data in the context of AI models. The opinion discussed whether AI models could be considered as processing anonymous data and discussed legitimate interest as a legal basis for processing personal data. One of the ways to mitigate the risk of using personal data in training AI models is to ensure that the data is properly anonymized and protected through the entire development process. The EDPB describes the criteria for an AI model to be considered anonymous. Data controllers need to implement anonymization techniques, consider all the reasonable means likely to be used to identify individuals, and evaluate the risk of identification by the controller and third parties, even in cases of data breaches. So just 2 days after this opinion, the Italian Data Protection Authority got to work by issuing a very important decision against ChatGPT. And this was a 15 million euro fine for failing to notify the authority of a March 2023 data breach and for processing users' data to train ChatGPT without first identifying an appropriate legal basis. This decision is one of the most significant actions against ChatGPT and shows the growing demand for accountability and transparency. And just one other point in terms of background for our discussion, that the definition of an AI model in the EDPB opinion isn't the same as the definition in the AI Act. And AI models in the opinion are those developed through a training process. Businesses should be aware of whether their AI model meets the definition in the opinion. So just to get us started, we're going to have a short reaction from our guests, our panelists, about the guidelines, the opinion. So we'll start out with Gert and then move around the screen. Thank you, Gert.
Happy to do so. So I think the EDPB guidance is well written with a clearly defined scope. I can imagine it was not easy for the EDPB to actually draft this guidance, taking into account that there is a lot of AI models, applications, nuances. We have generative AI, what you just discussed, but there is computer vision and others. So they needed to narrow down the scope, which they did, to AI models that, while potentially containing personal data, are not designed to process personal data related to the training data of that model. So I think they narrowed down that scope well. And they also did a good job at separating the development phase and the deployment phase. So from our perspective as a law firm, we see that most companies act on the deployment side. So what I will tell later, I'll present the use case on deployment. When we look at this opinion, when advising clients, we usually go through 4 steps. We'll first look at whether we are really talking about an AI model. This can already be difficult because there is no clear definition of what an AI model is, as opposed to AI systems. A second step, what processing occurs in the development phase and what processing occurs in the deployment phase. We will need to look at both. We will also look at whether the initial processing of data for training was conducted in compliance with the GDPR. And then we come whether to the point that you addressed, is there anonymization or not? What are means likely to be used to maybe identify still data subjects? And of course, we will need to make sure that the processing in both the deployment and development phase are in compliance with the GDPR. That's my first thoughts.
Excellent. Laureline, do you want to give some initial comments?
Yes, of course. Thank you. Very much aligned with Geert that this was, so to say, an impressive piece of work. The opinion, what we think is really important and noteworthy is that, yeah, the opinion does recognize legitimate interest as a legal basis, a valid and available legal basis for AI training. And we think it's noteworthy because we have also seen that from the start that was not the position of all the DPAs. And the opinion also notes very clearly that there is no hierarchy of legal basis, which it has, by the way, repeated recently in its the EDPB has repeated that in its draft guidance on legitimate interest. Of course, that does not mean that it's just a tick the box exercise or that it's carte blanche, not at all. The opinion is very clear on the fact that you need to show an interest, you need to show the necessity, you need to show that there is no that the balancing test is fulfilled, so that the negative impact do not outweigh the interests, and if, as the case may be, that you apply mitigating measures. And I think the opinion is very detailed on that. And so, from our perspective, we think that this recognizing legitimate interest was the right approach. First, in practice, it is. We know that AI requires comprehensive data sets in order to be qualitative, and they should reflect differences in regions, in languages, in persons, in contexts, and so on. So you need a lot of data to have good qualitative AI, and so legitimate interest is the most say logical. But that, as I said, that does not mean that it's an easy thing. I think that is also worth noting that the opinion sort of that often it was a bit seen like legitimate interest was the easiest of the legal basis, but we don't think that that is so, because it actually puts a lot of accountability on the controller, and I guess we will come later to that in how that evolves. But we think like the accountability is where sort of you have to prove that you're worthy of using legitimate interest.
Yeah, and we saw that right away with the ChatGPT decision, that they did have some serious problems, serious questions about their transparency and their accountability. Luca, why don't you give us your initial thoughts as well?
Sure. Well, I agree with what has already been said by my co-panelists, but I would also flag 2 things. One is that this opinion is quite narrow in scope in a way. It addresses 2 main things. One is whether AI models can be considered by default anonymous, and the answer is no. And then the opinion goes on explaining how one should demonstrate if an AI model is truly anonymous. And the second issue addressed by the opinion is, as already been said, whether legitimate interest can be used as a legal basis in this context. The answer is a yes, a general yes, or a yes in principle, but then the devil is in the detail. So I think a key takeaway for companies is that they shouldn't be looking for much more than this into this opinion. But of course, the use of AI, or both the training and the deployment of AI will trigger and come with much more data protection issues than the ones addressing the opinion. So don't look only at this opinion if you're looking for general guidance on data protection and AI, but do look at this opinion if you are considering, in particular, to rely on legitimate interest as a legal basis. I think this would be my starting point, but I'm sure we can cover much more as part of this.
Okay. Yes. So it's not a document that is going to answer all the questions about AI models. So it would be good to go into some of the details about what's practical for companies. You alluded to that a bit, Gert. And so some of the, if you can go into what some of the practical steps are for companies when they're developing and deploying AI models, so they're in line with the EDPB guidance.
Yeah, okay, happy to do so. As I said in the beginning, we mainly see companies deploying AI tools. I'm not going to talk about typical Gen AI tools like ChatGPT, Gemini, Copilot, or DeepSeek, as you mentioned. Instead, I picked out a use case that is relevant, I think, for many companies, ensuring a safe workplace. It's something that can now be done by the use of off-the-shelf AI tools. So the market is being flooded with off-the-shelf AI tools, by the way. And what I'm going to say now will apply to any off-the-shelf AI tool being deployed by a company. But I think ensuring a safe workplace is a good example. How have companies, employers been doing this in the past? They use CCTV images. If an accident happens, they'll look at the images, analyze them, learn from them, and make sure to implement better safety measures on the workplace to prevent these accidents from happening. And now AI is revolutionizing this. It does that by running live CCTV footage through the AI model. That footage immediately identifies potential safety issues in real time and will alert the employer about it. So, for example, an employee is coming close to blocking a fire exit or entering a dangerous restricted area. An employee is not wearing protective gear, using a machine incorrectly, which could potentially lead to lethal accidents. And the aim of the AI tool is to not run after the facts, to analyze images after the accident happens, but to actually prevent an accident from happening at all. And also to automate what we can call boring human tasks, looking at all these images. I mean, it's true. All of these tools promise a lot of efficiency, much faster, probably better, not always, because there could be false positives. But okay, the aim of the tool is, of course, also to improve itself. So at the speed that it's going, I think that the popularity of these tools will only increase over the next months. It's going fast. One thing is sure, whether AI is in the game or not, when you're using CCTV images from the workplace, you're processing personal data from your employees. So you need a legal basis, and the most appropriate will be legitimate interest, whether it's in the deployment context or in the development context. And in any case, free consent in an employment context would be difficult to obtain. So we can say, okay, legitimate interest. Then the next question would be, does the use of such an AI tool from an external vendor and that model behind it represent risks that require additional safeguards to comply with the GDPR? And we can, as you said, Luca, we need to look at the opinion, but not only at the opinion. But the answer whether we need additional safeguards for me is yes, because we're not only automating what humans have been doing up to now. First of all, you're sharing personal data, potentially sensitive employee data, with an external party, an AI tool vendor who acts as data processor. That vendor needs 24 access to the CCTV footage, which before was only accessible to your own employees. And it's also not unlikely that the data can be accessed from outside the EA. So that's one thing. And the second thing is you'll need to consider whether the data are used to train and improve the AI model. Most likely, yes, because the models want to improve themselves. So there you need to make a key distinction. Will your company's data be used exclusively to improve or fine-tune the model as it is used by your company, or will the data be used to enhance the overall model? And then also an additional risk in my view is, of course, that a lot of potentially sensitive data ends up with a third party who can also suffer a data breach. How can you best assess and address these risks when you're using such an off-the-shelf tool? First of all, looking at whether the model during the development phase was contained personal data and whether this data has been fully anonymized. I'm not going to go into the details, but you need to look at question 1 and question 4 of the guidance, and you'll see that it addresses the consequence of unlawful processing personal data during the development phase on the subsequent processing or the operation of the AI model. You just need to bear in mind that it is your responsibility as a deployer, i.e. the second controller, to be compliant. And the good thing is that many of these off-the-shelf tools, like the CCTV example I gave, but many others, are most likely fully anonymized, before you deploy them. So the risks are minimal. This is because we're dealing with what we can call narrow AI, designed for a specific task, and not generating new content, which would make it possible to retrieve personal data from the use of the tool in the deployment phase. So that's one thing. And then the second advice I think we need to give to any company wanting to deploy such a tool is that you want to be diligent in the choice of your tool vendor, making sure that the vendor has strong data protection measures by design and by default. So the vendor will have to demonstrate this, usually by documentation on the website, making sure that you comply with the safeguards set forth by the EDPB. Mainly, the technical measures can only be implemented by the vendor, of course, because once you're using the AI model, you don't have an influence on that. These tools also rapidly evolve, so it's important to follow whatever new functionalities the tool has in order to make sure that you're still using the best privacy enhancing or privacy preserving tool on the market. And of course, you want to conduct a proper legitimate interest assessment as part of your larger data protection impact assessment. I could add a few more things. The 2 more things I want to add is what are the typical safeguards that should be put in place by the vendor, and what are the typical safeguards that should be put in place by you as a deployer. For the vendor, as I said, mainly technical measures. The vendor will need to make sure that the principles of necessity, purpose limitation, limited data retention, pseudonymization or anonymization are guaranteed. For example, in the example of the CCTV, configuring the tool in such a way that it only processes the video data from actual incidents and not 24/7 images, that it's designed only to detect dangerous situations and to alert about them, and that it's not going to use the data for other purposes, definitely not for monitoring the employees, that it should not retain the data for longer than necessary. And also, what most of these tools do, they already, as I said, they need to have privacy by design and by default measures. For CCTV, often they will use face blurring mechanisms. So before the data is analyzed, the faces are blurred. But there you can say, is that enough to have anonymization? Probably not. I think blurring could lead to reverse engineering. So when these tools are improving themselves, and one example would be to not only blur the face, but also to turn the employee completely into an avatar. So 3D anonymization, so you cannot see at all who is behind it. And then what can you do as a company deploying the tool to be compliant with the GDPR. It's mainly transparency, training, and contractual. Transparency, properly informing your employees about the use of the AI technology, training your staff on it, on the data handling in the context of such a tool, and then also making sure that you have a good agreement with the tool vendor where you obtain strong warranties with regard to the data processing, such as, like making sure that the faces are blurred or even the avatars are created. Um, if you don't want the data to be used for model training, then you should foresee that. If you don't want data to go outside of the EAA, you may also want to request that. Yeah, I think that is, and of course, your general accountability, as it was mentioned by Laureline, making sure that you properly document your legitimate interest assessment for, yeah, to be able to defend yourself if there's any discussions later.
Thank you very much, Gert. That was a very comprehensive overview of all the requirements that companies should consider. Luca, I was wondering if you could drill down into just one thing that Gert mentioned, and it was about anonymity. So a big question, and there is a fair amount in the guidelines about this. But how can AI developers show that their models are truly anonymous?
Sure, thanks for the question. I think this is one of the two critical questions addressed in the opinion, and especially this part of the opinion is quite nuanced, technical, and detailed. So for those interested in the answer to this specific question, I would recommend going through that part of the opinion. But in short, the opinion concludes that, as I said, AI models cannot be presumed to be anonymous. One should be able to back up such claims and to show that, in accordance with the expectations set by the opinion, one should conclude and document that personal data cannot be extracted out of the model, and that any output produced when querying the model does not relate to the individuals whose personal data was used to train the model. In other words, one needs to show that the likelihood of identification is, in the words of the opinion, insignificant. And I think the term used by the opinion here is quite interesting because it's different from the existing standard that we can find in the guidance from 2014 on anonymization from the Article 29 Working Party, which talked instead about identification as something that should be reasonably impossible. So arguably, the standard set by the opinion is slightly softer here. And so to show anonymity, one in practice needs to conduct some sort of identification risk assessment. And this risk assessment should be done taking into account factors like available technologies, the information that one would need in addition to the one that are already available to, let's say, the developer for identifying specific individuals behind the data, and also the cost and the amount of time that one would need to spend for seeking this additional information necessary to identify specific individuals. It's also important to make this assessment in light of possible re-identification by unintended third parties. So one should not only assess the risk of identification based on, let's say, as I said, the information already available to the developer and the intended users of the AI tool, but also potential unintended third parties who might have an interest in identifying specific individuals by extracting data out of the model or by querying the model itself. One thing to also bear in mind is that the opinion says that one should do this assessment taking into account the most recent guidelines from the EDPB. And as I already mentioned, there is guidance on anonymization from 2014 that is still deemed relevant by the opinion, but it's also important to remember that this guidance is soon to be replaced by new guidelines on anonymization that the EDPB is currently working on. And companies also should bear in mind to keep an eye on the upcoming judgment from the Court of Justice on this, on the case that is currently pending before the court between the EDPS and SRB, which could also come with significant development in terms of how anonymity should be assessed under European data protection rules. I think, to conclude, I would also highlight that the opinion provides an exhaustive list of methods that developers can use to make sure that their models are anonymous during the development phase. So these are probably measures that one should consider to make sure that later on those claims of anonymity can be made. But again, in practice, it might be more or less difficult to show anonymity depending on the context. And here the opinion highlights that, for example, it might be more difficult to prove anonymity for AI models that are intended for use by the general public compared to AI tools that are only for internal use within the company. So again, like always in data protection, context is very important, and the opinion reminds us of this.
Also, the one thing that came across to me was this whole idea of the case-by-case analysis that's really important for any companies. Yes, this SRB case is going to be extremely important, and the opinion is coming up in just in a couple weeks. So we'll be covering that at MLEX. Just wanted to turn to our other speaker, Laureline. So we heard from Gert and Luca about the some practical advice for companies. But I was wondering if your view is that if you can help companies, if you think the opinion is going to help companies assess the risk of using AI tools. I mean, how practical is this guidance?
So I think the first thing to be aware of is that the opinion focuses on models. It does not focus on tools. I think Geert has been giving more explanation on how to deal with tools than the opinion does. But of course, every tool is based on an underlying model, and the opinion makes clear that also for the persons or companies or whatever that use tools, they will have to think about the solidity of and the compliance of the underlying model. And I think that in that sense, the opinion is, I would say, gives a lot of tools, gives a lot of elements to the deployers, I would say, especially when it comes to risk assessment, risk management, mitigation measures. The opinion is quite, it's not prescriptive. It's clear that whether it's pseudonymization, as Geert has mentioned, or filters or other, but the opinion does not prescribe. It's not like a checkbox, but obviously it gives a lot of examples, and I think in that sense, the opinion is helpful. When it comes to Microsoft, when we so for the training of our large language models, what we plan to do is use consumer data, and we want to do that, of course, in accordance with the EDPB opinion, which is also why we are discussing currently with regulators, and some of the mitigation measures that we are implying, because we haven't deployed it yet on EU data in Europe. So the training has not been done on EU data, precisely because we are discussing this. But examples of measures that we consider putting into place or already do it in other regions is, of course, opt out. Also, certain data, not using certain data, certain types of data. For example, those users that we know are below 18 don't use the data for trading, or for B2B customers, we don't use the data for training. Equally, sorry, and that has also been mentioned in opinion, filtering and scrubbing data from personal identifiers at the output level, doing red team testing, and also filters to avoid that personal data is reproduced. All of these things are elements that developers can put in place, and that deployers will then sort of go and check, as Geert has explained it, by the way, go and check when they deploy certain tools based on those models. And I think, by the way, that in addition to checking whether the models comply with GDPR, I think that customers will also increasingly look at whether developers comply with the AI Act. So that's another set of documentation that will be relevant, and that's, by the way, mentioned also in the opinion.
Yeah, that's really very important. And just to remind our listeners, the first possible enforcement will be on February 2nd through the AI Act, and those are the prohibited measures, prohibited actions. And we'll see what the AI office comes up with in terms of enforcement. The other thing to recall is that Google, Meta, and X are all currently being investigated by the Irish Data Protection Commission for how their AI models comply with EU data protection rules. So we're possibly going to get some more, let's say, details about how people interpret the rules soon. We had the first off the bat was in Italy, as I mentioned at the start of the call. So just to drill down a little bit deeper into this issue of legitimate interests that we've already discussed, but in practice, I'd like to go back to Luca and ask him what he thinks in terms of legitimate interest as a legal basis, and how difficult it might be for companies to rely on that, and if should companies review their legitimate interest assessments in light of the opinion.
Sure. Well, I think, first of all, the good news for companies in the opinion is that it does not rule out the possibility of relying on legitimate interest as a legal basis. I think there was a bit of fear before the publication of the opinion that regulators would move towards consent as a default rule in this area, and that was something that the opinion didn't establish. So as a general rule, legitimate interest can be considered as a legal basis. However, again, the opinion demands a case-by-case assessment of this. And I would think that two of the three criteria in the legitimate interest assessment will be more challenging than others to prove and assess for AI tools. The first is the necessity test, and that's because to prove that the necessity test has been successfully passed for a specific AI tool, the deployer or the developer would also need to prove that there's no less intrusive, reasonable alternative to the use of this specific AI tool, which in practice may sometimes be challenging to prove. But I think the opinion shows some flexibility here, in particular for controllers that have adopted measures that reduce the likelihood that data subjects can be identified. Another part of the balancing test that can be a bit more tricky for companies is the one connected with dealing with the reasonable expectations of data subjects. This is because, as you know, reasonable expectations of data subject play a key role in the balancing test for legitimate interest assessment. And in this case, given the lack of general and full understanding of how AI tools work in practice, it will be good for companies to try and adopt transparency measures in addition to having a good privacy policy in place that would somehow educate users about how AI tools work and their privacy implications. This has been, for example, a key element in the ChatGPT case, Italian ChatGPT case you just mentioned. And the opinion also stresses this by listing a number of specific transparency measures that companies can consider adopting to, let's say, rebalance the reasonable expectations of data subjects, in addition to having a good and detailed privacy policy in place. I think in general, it's also important to bear in mind that the documentation expectations have generally become higher in recent years. So I would think that is a good idea for companies to review at least their most critical legitimate interest assessment to make sure that they meet the high standards set by recent EDPB guidance and EU case law. And it's also important that when doing so, they consider involving their DPO. This is also because the opinion stresses that the involvement of the DPO is one of the elements that data protection authorities will consider if they will investigate whether the legitimate interest assessment has been done properly or not. So I think, generally speaking, it's good to consider legitimate interest assessments as living documents and review them from time to time, in particular in these critical and evolving areas, and for all processing linked to AI.
Excellent. I just wanted to point out we do have a question from the audience related to these assessments, but it's about data protection impact assessments for high-risk AI systems under the AI Act, and how they might differ from the requirements in the GDPR's data protection impact assessments requirements. Does anyone want to tackle that?
I
know
can
it's
maybe
tangential.
I can maybe quickly jump in, and I also building on what Luca said. So I do think legitimate interest is there. It's not meant to be easy. It's an accountability exercise, as you said, Luca. And I do agree with you that the weight of data DPIAs will become more will become bigger, and the importance of that. And we see already, by the way, that in the past, DPA would basically not be interested in a DPIA, and today we see that that interest is there. And I do 100% agree with you that the legitimate interests element will play. It has to play a strong role in that. But then on the question, it's a bit. I mean, it's a bit further away in my memory how exactly the AI Act is, but I think where there is a certain overlap in the sense that the AI Act is meant to protect fundamental rights, and privacy is one of the fundamental rights, but also safety and health. And there we see that it's a broader scope. So I think that will definitely be a different focus. On the other hand, what we see in the data protection world, for example, the ICO had a lengthy discussion with Snap on its DPIAs, and it led to a decision ultimately where the ICO was happy with Snap's DPIA, but Snap had to review its DPIA. And in that decision, we see interestingly that the ICO also, it was about AI tools. Interestingly, the ICO spends more and more attention to exactly safety and security and copyright elements that are So we see there is a difference, but I think we also will see increasingly an overlap.
Yeah. Well, all those questions are going to come up very soon in this code of practice that's being discussed right now. I'm sure everyone on this call is following that, and hopefully some of our audiences as well, because that's going to be key when the actual AI Act goes into effect in August. We do have another question. Very happy to get these questions from the audience, and it's focusing on how companies can balance AI innovation with GDPR compliance, especially when using off-the-shelf tools. And I think it could be good for Herrick, since he mentioned that in his opening statement.
Happy to jump in here. I think that feeds into two things that have been mentioned in the past minutes, which is, well, of course, the legitimate interest assessment and improving it, and then on the other hand, the case-by-case assessment. So if I jump back to my example of CCTV footage, of course, companies needed a legitimate interest assessment already when they were just looking at images. If you were going to rely on an AI tool, Luca, you said, of course, we need to look at the necessity principle, proportionality, reasonable expectations. Do you really need an AI tool only to improve efficiency, and reduce human tasks? That would probably not be a sufficient argument. But I think if you can increase safety, and on top of that, you implement adequate mitigation measures as they are listed by the EDPB. I think it's a useful guidance also, when you look at the list of mitigation measures, then you can actually justify that it's proportional, that it's less intrusive because of the measures that have been put in place. And you can also justify it towards the data subjects as being, meeting their reasonable expectations, because you can show that there are appropriate measures in place to counter the additional risks. And there I wanted to add one point. Of course, as a company deploying these technologies, it's not always easy to understand the entire context and the technical issues. So I think there will be a role for certification in the future. These especially off-the-shelf tools could rely on GDPR certification or other types of certification that would help companies that want to buy these tools to actually be reassured that they meet the necessity test, the proportionality, and reasonable expectation.
Okay. We don't have too much time left. I just wanted to get back to a question that came in on the chat about synthetic data. And if anyone on the panel wants to tackle this one, it's the use of synthetic data. Is that seen as a valid solution? And if anyone on the panel has any experience with that, anyone wants to jump in on that?
Luca, do you want to go? Otherwise, I can.
Go ahead, Luca. Looks like you're.
No, I can say two words, and maybe you can complement what I said. I think the general answer is yes. I think it's a good at least mitigating measures. I think even in Norway, as part of the a regulatory sandbox run by the Norwegian Data Protection Authority, there has been also specific studies on the use of synthetic data for mitigating data protection concerns connected with the use of AI. So the general answer is yes, and there is experience out there with this, but maybe Laureline can complement this with her own experience.
No, I think there is just yes, I agree with you. Just using only synthetic data will also have a quality impact. So I think it's and there we look at what at the framework of the AI Act, and so we need to take both into account.
Okay. We just have a couple minutes left. I'm just going to ask our panelists to end with any kind of closing remarks. And let's start with Hert.
Yeah, nothing in particular to add. I think this was a very useful debate. There's a lot of criteria we need to look at. So given the rapid speed of this is going, we will need to follow up closely. And I'm also anxiously waiting for the new guidance on anonymization, and as you said, new case law. So we need to stay on top of this very closely.
Yeah, just to the case that Luca mentioned, the SRB is coming out on the 7th of February. So watch out for that. And at MLEX will be following, of course, the new guidance on anonymization. Luca, you want to?
For me, the key takeaway for companies is that they should really be serious about documenting their assessment now, as also Lorelina has pointed out, because these will be very critical in the context of potential enforcement, and the action taken by the Italian DPA shows that enforcement can come any minute. So this opinion is certainly not to be forgotten, and I think for many companies, this will require revisiting a bit their internal routines on how, in particular, legitimate interest assessment are done and documented. So I think that is something that people
transparency. It's a big issue. Laureline, any closing thoughts?
No, the gentlemen have summarized it so perfectly that thank you for this.
Wonderful. I neglected to introduce myself at the very beginning. My name is Matthew Newman, and I'm a global correspondent here at MLEX. I also want to invite everyone to stay around later today on Data Protection Day, because we have another session with privacy rules in MLEX, and that is focusing on North and South America and tackling the use of teens and children's data. So I invite you to come back for that. It's with my esteemed colleague, Mike Swift, who's joining us from San Francisco. So I really would love to have you back for another session. I want to thank very much our three panelists. They've added their expertise, and I think it's very clear that they know exactly what they're talking about. So I'm hoping everyone who listened and tuned in got as much out of it as I did. So thank you again, Laureline, Gert, and Luca, and I look forward to more conversations in the future. Thanks again.
Thank you.
All right. Thank you.
Thank you.
Bye, Matthew.
Bye.